Supreme Court judges will from tomorrow sit to hear the appeal case on the Building Bridges initiative, which was shot down by the High Court last year, which termed the entire BBI process unconstitutional. So in a three-day sitting, the Apex Court will hear the appeals filed by the Attorney General Kihara Kariuki, the Independent Electoral and Boundaries Commission, as well as lawyer Morara Omake. And to perhaps get a clear picture of what we expect this week is constitutional lawyer Charles Kanjama. Thank you, Charles, for joining us. For those who've lost track of the case, really, what are we expecting to see tomorrow?
We're expecting to see an array of lawyers representing each of the main parties to the petition, the three appellants, the respondents, including, of course, the team that led the petition against Bridges initiative. We expect to see the 7 judges of the Supreme Court sitting to listen to these parties. The case will begin with the appellants, who you have just mentioned, the Attorney General, the Independent and Electoral Boundaries Commission, and Morara Omoke presenting their arguments, and then the respondents will each present their argument. The appellants are saying that the High Court and the Court of Appeal were in error when they declared the Building Bridges initiative project unconstitutional. They'll be trying to persuade the court that BBI is constitutional and should be allowed to proceed.
Right. Wakili, there are a number of contentious issues that were raised back then in the courts. We'll get to that in a moment. But I think the question that many Kenyans are asking at this point, will be the decision by the Supreme Court be binding once and for all and settle the BBI matter?
Yes, the Supreme Court is the apex court in Kenya, which means the Supreme Court is the final decision, and whatever way this matter, once not only settles the matter regarding the Building Bridges initiative, it will also be expected to give clarity on any future attempts to amend the Constitution by popular referendum.
Right.
Or popular initiative.
And are there timelines to, the Supreme Court ruling on this matter?
There are no fixed timelines in the law. Once the Supreme Court hears the case over the next 3 days, they will give a determination as to when, or an indication as to when they are likely to give their substantive decision.
Right.
We did see that in the case of the Court of Appeal, they took about 2 months to give their judgment. I would anticipate that the Supreme Court, considering the weighty submissions and arguments that will be made by the parties, might probably give a similar timeline.
Right. So, not really, looking at the court's directive, and this is an issue that has come up after the directive that was given by the court in terms of the time that was given to the proponents as well as those against the case, is that the appellants have been given 45 minutes each to highlight their submission. The respondents have also been allocated the same amount of time, but for example, the Attorney General has written to ask for more time, saying the issues are so weighty that they would need more time to hear. And I've seen other constitutional experts asking the Supreme Court to allow the appellants more time to give them the time to raise the issues that are in court.
I would say this is a typical procedural issue. It happens very frequently when advocates appear before the court, including the Supreme Court. There is normally a bit of haggling about how much time the parties hope to be given to present their case. It's a procedural matter. Ultimately, the judges of the Supreme Court will have the final say on how much time is given to each of the parties. But having perused the letter by the Attorney General's, the Solicitor General requesting for more time, it is possible that the Supreme Court judges could adjust the timelines for purposes of a level playing field between the appellants and the respondents.
Right. So there were a number of issues. We had, the issues that were raised include whether the president can initiate changes to the constitutional by to the Constitution by popular opinion, whether the BBI proposal to create 17 new constituencies was unconstitutional, whether the civil proceedings can be instituted against a sitting president. They're also seeking to determine the place of public participation in amending the Constitution, the minimum quorum required for the IEBC to conduct its business, among other issues. If they're not just to preempt probably the court's decision, just in case the court rules in favor of the proponents of this case, what political implication will that have?
So if the appellants in the Supreme Court succeed in their various arguments, because they would need to succeed systematically in virtually most of their grounds of appeal, then there would be some implication, because it would mean that even though we are preparing now for the general election and there is hardly time to proceed with the Building Bridges initiative process, we are already approaching the 6-month time frame for general elections. It would be a moral victory for the pro-BBI team, and it would mean that the process of pursuing a referendum can continue. The practicalities of having it before the general elections, of course, is a different matter altogether. If the proponents of the BBI bill, who are some of the appellants, fail, then of course it will be a greater moral victory for the respondents who have challenged the BBI bill all the way from the High Court, and it would be the final nail in the coffin to the attempts to use the popular initiative to effect wide-ranging constitutional amendments.
Right. And lastly, Wakili, just to wind up, tomorrow, what should Kenyans be really keeping a very close eye on as the ruling and the hearing begins?
Okay, so one of the things that we lawyers do is we study the body language of the judges who are going to make the final decision. Judges of the Supreme Court tend to be interactive. They will ask some questions. They will seek to be persuaded on certain issues. And it's always interesting for observers to note what kind of questions or issues the Supreme Court judges will be highlighting. It will also be interesting to see who are the various counsel who are raising different arguments on behalf of the Attorney General and the other appellants, and how much time they will be given to argue their cases. And then finally, it will be interesting just to remind ourselves about the core arguments that were made in the High Court and in the Court of Appeal, and the reasons why the appellants are claiming that the Court of Appeal judges erred in the decision that they made.
All right.